So I have one disclaimer that Claire's introduction reminds me of. I did my best to say privacy, but sometimes it comes out privacy, so please excuse that. All right. Now, I'm very pleased to be here to speak at this conference whose theme is challenges to justice and dignity, because my work is connected to that, I think, quite directly. And I noticed that many of the sessions concern challenges to dignity and justice from law itself, whether constitutional law or statutory law or judicial decisions. And I'm investigating something different, which is a challenge that comes not directly from law, but rather from patterns of social behavior in which law necessarily operates. There is, of course, an ongoing relationship between law and social behavior, and most of us tend to think of that relationship as top-down. So the law says you may not do X, steal, have 2 wives or husbands, attend school until school-leaving age. And as a result of that, most of us are honest, monogamous, and can proceed with our lives able to read, write, and reason. But I want to invert the order of those things and look at how our behavior, how social behavior affects both the content of law. That's the main argument I want to make. So instead of taking it top down, I want to use what I'm calling a trickle-up theory of the relationship between law and behavior. And I want to look at a specific behavior, specific social practice, and that is the keeping and disclosing of secrets. And I'm looking at that in the very particular area of abortion. And by abortion, I simply mean abortion law, by which I mean the legal regulation of decisions by women to terminate pregnancies that are or that have become unwanted. And the final sort of introductory thing to say is I'm writing this against the background of the law in my own country, the United States, where abortion is legal but highly regulated. And I think that what I'm saying will have only intensifies in countries where abortion is illegal, but we'll leave this to Máiread. So I want to begin formally by going back to what a decision you may know, Roe v. Wade, which is Roe v. Wade, which is a 1973 case from the U.S. which found that the criminalization of abortion was unconstitutional. It's our starting point for legal abortion. And in the case itself, Jane Roe was described by the U.S. Supreme Court as, quote, a single woman residing in Dallas County, Texas. And she had filed her suit against Henry Wade, who was the elected district attorney of Dallas County, and he was the man responsible for enforcing Texas's criminal abortion statute. Now, but a quick footnote, so we know a lot about Henry Wade, but a quick footnote in the case following the court's first mention of Jane Roe informs us only that the name is a pseudonym. Now, this raises a very interesting, and I'm not going beyond the title of the case. This raises an interesting and very little discussed aspect of the case. When can a party to litigation decide not to use his or her own name, but sue instead under a fictitious one? A basic requirement of the adversarial system is that a complaint must name all of the parties. Not only does the defendant have a right to know who sued him, but the press has a right to report on it to the rest of us. As the U.S. Supreme Court said, what transpires in a courtroom is public property. The people have a right to know who's using their courts. So what are we to make of Jane Roe? How does it come about that a party may appear in court under an alias? What characteristics of the plaintiff or of the case so overwhelm the presumption of disclosure mandated by procedural custom that one can, in fact, proceed this way? I'm not going to answer that technical sort of procedural question very much, except to say, for now, that suits involving abortion are among the few exceptions where courts permit plaintiffs to proceed anonymously. Now, bringing a lawsuit under an alias is one instance of women keeping a distance between their names and the subject of abortion. But even outside a public courtroom, the practice is quite common as a matter of everyday life. No worries.
Sorry.
Now that the jury is here, we can continue. Women in the U.S. don't talk much about abortion as a personal experience. They don't tell their friends, except maybe a very good one who'll drop them off or pick them up afterwards. They don't always tell their husbands or partners. Young women tend not to tell their parents, and mothers rarely tell their children. Even in pro-choice families, the news can be unexpected and unsettling. One young woman described how after her middle-aged mother confided in her that she herself had had an illegal abortion while a college student in 1972, said, "It took a few years for the shock to wear off." The daughter had thought that a right to abortion was something that only affects other women and not my family, and certainly not my mother. Many women don't tell their insurance companies, even when their policies cover abortion, so that the procedure doesn't become part of their computerized medical records or an invoice from the company or a notification sent to their home addresses. Women with family doctors don't always tell them, but travel instead to places further away, not always sure about how their own doctors will respond to it. As one woman said, even if he never showed any sign of disapproval, I would from that day on be a lot more leery about how I was around him. And I mean, this is the person who follows you through your pregnancy, close quote. Even waiting rooms are fraught. A high school teacher in Little Rock, Arkansas, explained, "It makes me nervous even being in the waiting room. You don't want to know who's there, you don't want to be recognized, and you don't want to see them ever again." So although my focus on this lecture is on women patients, it's worth noting that those who provide abortion services in the U.S., that would be doctors, nurses, technicians, counselors, guards, and receptionists, often wear first name only name tags and don't always tell their own families where they work or what they do. Now, these many forms of concealment are examples of what I am calling abortion secrecy. The term secrecy seems a fair description of the deliberate non-disclosure that regularly accompanies planning or having an abortion, and that best explains the often furtive behavior that marks abortion as an experience that is something best hidden. There is, of course, another way to describe all this. One might say instead that women choose to keep their abortion histories or intentions under wraps, not because these matters are secret, but because they are private. By private, I mean simply that certain information, usually important, usually personal, falls within a zone of control that as a cultural practice, and sometimes as a matter of law, is the person's alone to reveal, not because it must be hidden, but because it's nobody else's business. This morning I want to explore the differences between privacy and secrecy in the context of abortion. And I'm going to develop the argument that secrecy, rather than privacy, is often the more accurate description, characterization of the concealment around abortion, and that the distinction between these two forms of non-disclosure matters crucially in how women experience the decision, the procedure, and its aftermath. So a quick word about what I think is at stake here. The distinction between privacy and secrecy matters most with regard to how individual women fare. Both the burden of keeping a secret and its unbidden disclosure are sources of harm. And I develop what those harms are more in a different chapter. And this is all part of a book, so I will occasionally speak about chapters. But the distinction between privacy and secrecy also matters with regard to another concern. This is the importance of abortion talk, how abortion is discussed. And so I want to say a few words about that right now. I am interested in the connections between private discussions and public discourse, and between public discourse and political deliberation. And my argument here is fairly simple. It is that the absence of private discussion about abortion distorts the nation of public debate, which in turn distorts or disfigures the legislative process. And this is the sort of core of trickle-up, that law often commands from below, but the content of it is often informed from what comes up. Now, we can't separate private discussion from public politics because people approach the public debate on abortion partly on the basis of what they know and what they talk about. Thus, my claim about the upward progression from private to public to political rests on three assumptions. The first is that legislators that legislators want or should want to have a sound factual basis for deciding how something should be regulated. The second, I take for granted that what women have to say about abortion, recognizing that women do not all say the same things, provides the best factual basis for what the experience of abortion is like. This idea about listening to women is a familiar point within feminist methodologies, which have long accepted that women's accounts of their own experiences is a touchstone of authenticity. But the point is not limited to feminists. In considering the question of whether it's possible to regard the death of a fetus in early pregnancy as the same as one would regard the death of a born infant or child, philosopher Bernard Williams states, "In the end, the issue can only come back to the experience of women. This is not because their experiences are the only thing that counts. It is because their experiences are the only realistic and honest guide we have to what the unique phenomenon of abortion genuinely is, as opposed to what moralists, philosophers, and legislators say it is. It follows that their experience is the only realistic guide to what the deepest consequences will be of our social attitudes towards abortion." So without this honest guide, facts one might want to know rather than to surmise or imagine are missing. This is a matter of concern because information considered by legislators in their efforts to regulate abortion, at least in the U.S., of late have been quite partial in what information they listen to. Public testimony of trauma, grief, and guilt is sought out and publicized, while others, and I suspect there are some who have not experienced trauma, grief, and guilt, remain silent. So the final point about the relation between private conversations and more public and political ones is the assumption, my assumption, that there is a trickle-up effect, because my claim about the movement of information has to be more than just a hunch or a grown-up version of Chinese whispers, or what we call telephone. So just how exactly might talking about the issue among family or close friends open the way for wider consideration of the issue at the level of politics, particularly such a tricky issue as abortion? The answer requires identifying the processes and structures of transmission that I think will help explain how the migration of once secret information moves into more public realms. And at the end of the talk, I'll just briefly describe 4 such mechanisms that I think help explain this. But this right now is getting ahead of the story. The issue posed initially is simply whether to consider women's reluctance to talk about abortion as privacy or secrecy. And as I've tipped my hat or hand towards secrecy, I want to make a case right now for the importance of privacy. What is it? What values does it protect? And what does the law have to say about it? So I want to begin with terminology. In contrasting abortion secrecy to what I call abortion privacy, I'm using the word privacy in a different sense than is often associated with abortion, at least as a matter of constitutional law in the U.S. Roe v. Wade held that it was the right to privacy that secured women's right to choose an abortion. Privacy was the umbrella concept under which expressions of liberty, and in this case the right to choose to terminate, were lodged. Because this form of privacy respects the personal autonomy embodied in the right to make one's own decision about such an important matter, it is sometimes called decisional privacy. There is, however, another important dimension to privacy. The decision in Roe may have given women the right to decide, but it said very little about a woman's right to control publicity around the decision itself once made or implemented. And it is this aspect of privacy, informational privacy, that I'm focusing on here. You can see that decisional privacy and informational protect different interests. The first protects the right to make the decision, the second the right to keep it to yourself. And we can see that they're certainly connected, but the point I want to emphasize is that the thing that is more important is to see that the right to choose isn't much of a right if its exercise can be prevented by the fact that others have knowledge of the decision. The Supreme Court, the U.S. Supreme Court, has recognized the possibility of power plays by husbands or by husbands over wives and by parents over daughters. Thus, as a matter of constitutional law, to make sure that wives and daughters have still got the right to choose, the court has held that states may not condition their consent to abortion on parental or spousal consent, which many states had tried to do. But the relation on the idea that husbands could just keep wives at home, and that parents could put children and daughters in their rooms, lock the door, physically keep them away. But I think that informational privacy, the problems of it, go beyond the brute pressure that literally blocks a pregnant woman's access. There are more subtle forms of prevention, such as the possibility of disclosure. And as Justice Stevens observed in a case involving pregnant minors, it is inherent in the right to make the abortion decision that it may be made without public scrutiny, because without privacy, one's choice is effectively made by others. So in this way, informational privacy is tucked into decisional privacy, and it has to be, one would argue, it has to be protected in a way that ensures the anonymity of the patient. Decisions about abortion are thus complicated by women's awareness of the possibility of exposure by one means or another, and the consequences of that disclosure. In a 2004 case quashing the U.S. Attorney General's subpoena seeking patient abortion records from a Chicago hospital, a federal district court described the situation this way. American history discloses that the abortion decision is one of the most controversial decisions in modern life, with opprobrium ready to be visited upon the woman who so decides and upon the doctor who engages in the procedure. An emotionally charged decision will be rendered more so if the confidential medical records are released to the public, however redacted, for use in public litigation in which the plaintiff is not even a party. Patients would rightly view such disclosure as a significant intrusion on their privacy. So we have the immediate worries about disclosure. But I want to suggest that the threat of disclosure is not time limited. At least in the U.S., it lurks around the edges of women's lives. Questions about abortion, including abortions in the distant past, have turned up in all sorts of connections: employment applications, political campaigns, custody fights. To take but one example, in a California case, a woman applicant for a police officer was questioned by a polygraph examiner, put on a lie detector test, about whether she had had an abortion and with whom she had gotten pregnant. And although a federal court ultimately found that this form of questioning directly intruded upon her privacy, I think such practices continue today for at least three reasons. Job applicants don't always know a question is impermissible, and even if it seems like it must be, knowing that you don't answer will finish your prospects for the job. And finally, suing to vindicate one's rights is a difficult matter and only brings more publicity to the thing you wish to keep to yourself. So let me now turn to what we mean by privacy, and I'll go over this very quickly. But I think the essence of it is that it is the claim of an individual to determine for themselves when, how, and to what extent information about them will be provided to others. This is a good start for thinking about privacy, but the question is, what is it about this information, about particular information, in contrast to all others that one might like to keep secret, that privileges it as a matter of privacy that we think ought to be protected? Not everything a person prefers to keep to themselves, one's age, true hair color, criminal or marital record, or fill in your own thing, is regarded as private, so that norms of non-intrusion attach and the claim to privacy is expected. So we want to focus on what counts as privacy for the purposes of being legally protected. We know that from tort law that information can be protected if its disclosure is such that, quote, a reasonable person would feel justified in feeling highly aggrieved by its disclosure. Hence, the Supreme Court's, the Court's comment in the medical record case that I just read, that patients would rightly view such disclosure as a significant intrusion upon their privacy. But expectations of privacy are subject to certain qualifications. For example, privacy, at least under U.S. law, can be of has to be about an issue that is of no legitimate concern to the public. In a 1995 Michigan case, anti-abortion protesters argued that because abortion was an issue of legitimate concern to the public, surely true, that two Doe plaintiffs had no privacy interests in regard to their actual names being displayed on large signs held up for public view as the plaintiffs entered an abortion clinic. The protesters were two nuns who had obtained the records from a dumpster. So the trial court agreed with the protesters and said that because abortion is so controversial in our society, it is a matter of great public concern. This was reversed on appeal by a court who said, yes, it is a matter of great public interest, but we're interested here in the privacy interests of two particular women. And the court distinguished between issues that were regarded as public interest and the public's identities, which were not issues of public interest. There are other exceptions to the right to keep personal information to oneself, and a large exception includes public records, which generally defeat a claim to privacy with regard to the information they provide. I don't know if you have this here, but a new disgusting thing has come up in the U.S. that mugshots, which are public records, have been, some people, entrepreneurs, have seized on them, post them on websites for the purpose of being paid to take them down by the people whose mugshots are put up. You know, you have one drunk driving incident, one whatever. And I just want to mention that because you begin to see the importance of whether abortion records are in any sense public as to what can happen to them. Now, I'll give you an example. In the U.S., state driver's licenses are traditionally considered public records, as are state-issued license plate numbers. And so anyone can go to the Department of Motor Vehicles, provide the license plate number of a car, and receive the name of the person who owns the car. Certain pro-life groups have done just that with cars parked outside abortion clinics or doctors' offices where abortions are performed. In one case, and there are many, the woman had gone to an OB/GYN specialist for care during a very difficult pregnancy, which later ended in miscarriage. A few days after she went to the office, she received what the court called a venomous letter discussing the guilt of having killed one's own child and God's curses for the shedding of innocent blood. This came from a pro-life organization called Operation Rescue. Her case was but one that led to the enactment of the Driver's Privacy Protection Act of 1994, which as a matter of federal law, prevented this divulging of the owner of a car. In addition to information in public records, claims to privacy are also compromised when the person has in some way made the information available. And so, for example, if you do something in public space where anyone can see you, that is not private information. This is quite problematic when women walk on public sidewalks to abortion clinics or medical offices and have their photos taken by minicams, which are then also posted online in the U.S. And there's also a little bit, do you call it postcode lottery here? Okay, so there's a little bit of that going on in the U.S. In one case, in a small city in California, a health center sought to bar protesters from standing at the gate of its parking lot. The city Chico was so small, they argued, that protesters would likely to be able to identify patients as they entered. But the court found for the protesters, saying, having chosen to live in the environment of a small city, the plaintiffs cannot expect the courts to guarantee them the kind of anonymity they might find in a large metropolitan area such as New York. So remember that. So the other point about privacy is that information is not privileged if you voluntarily waive your right to privacy. And We have all waived a great deal of our rights to privacy, I think here, at least in the U.S. again, with regard to our contractual relationships with Internet providers, retailers, and credit card companies. And I am putting aside for a moment the massive involuntary data collection by our various agencies of the state. So, for example, the megastore Target, do you have Target? Oh. Now uses something called predictive analyses based on customers' prior purchases to figure out what else she is likely to buy in the future. One example that made headlines, the headline was, "How Target Figured Out That a Girl Was Pregnant Before Her Father Did," involved Target's assessment that the customer probably was pregnant. And I'll just say, home pregnancy tests, scent-free items, and certain vitamins are 3 of the 25 data points used to detect for pregnancy. Target then sent coupons for diapers and cribs to the teenager's home address, to the puzzlement and fury of her father. Interestingly, it turned out that she was pregnant, but that's beside the point. So certainly what we see is that there is surely data points for finding out if a person is pregnant by consumers who just want to sell you stuff and might, I mean, I think they might be able to detect if you buy a pregnancy test and then you don't buy vitamins and such, then maybe you are no longer pregnant or never were. In any case, you see the possibility for the uses of predictive analyses. Certainly, the metadata accumulated by our security agencies could be mined for abortion-related data. Indeed, in testifying before a committee of the European Parliament, Glenn Greenwald used abortion patients as an example of just what metadata could make possible by finding out where a person went, what phone calls they made, and so without knowing the content of those phone calls, you can piece it together. But even in the midst of all this data culling and coupon sending, there remains an established notion of the right to be left alone. Now, and I already mentioned torts, where every individual has some phases of his life and activities and some facts about him he keeps entirely to himself. Now, there is a problem in that not everyone keeps all phases of his or her life too close to the vest. As a culture, we, and here I do speak only about Americans, have become hugely confessional and massively indiscreet. But even amongst, just take a bus, turn on the radio, I mean, people are blabbing out all sorts of things that you'd think, keep it to yourself. But I think there are still some things that people keep to them that do regard as private. And we see that there are sanctions that the law offers upon whatever those matters are. Some of the sanctions, some of the ways that things are kept private are through voluntary restraint, such as when news media refuse to publish the names of rape victims as a matter of professional ethics. But still, some are social constraints, as when someone fears that they don't want to be known as a cad within, or a loose person within their community, with that operating. And still others are legal in character. Plaintiffs may sue for money damages using traditional common law torts as defamation, invasion of privacy, intentional infliction of emotional distress, and so on. When the privacy is invaded by the state, you can sometimes get an injunction to prohibit the state from collecting that sort of information. An example was the public records on births and deaths in New York City in the 1970s collected not just statistics about abortions, but the name of the patient. And these were part, again, of the public records. And the court said, no. Okay. Why is privacy taken so seriously? I think the key is that it is largely a matter of an expression of autonomy. There are things we wish to keep private about ourselves. As Ferdinand Schoeman has explained, privacy provides the context for personal objectives being respected. It is a private sphere of valuation. One develops one's own values and tries them out or on to see if they fit. And this is a tentative process, sometimes taken with hesitation, and whether this experimentation in how we live leads to embarrassment, regret, or a lifetime of happiness, this process of experimenting is important for the development of self-definition. Legal sociologist Kim Shepley has observed the ability to reveal or to hide information is crucial to an individual's ability to shape the social world in her immediate vicinity. So Patricia Spacks, a literary scholar, says that it's the voluntariness associated with privacy that distinguishes it from, quote, less desirable forms of seclusion, such as loneliness, alienation, ostracism, and isolation. So there is something empowering, something self-defining about the exercise of privacy as an aspect of choice and autonomy. This is what explains, in Spacks's phrase, privacy's self-evident desirability. And it is exactly on this point that I want to distinguish privacy from secrecy. If privacy embodies self-evident desirability, secrecy appears to me to be a more ominous proposition. Secrecy suggests it is best to keep a matter to yourself, not simply because, all things considered, you prefer to do so as a matter of self-definition, but because of the apprehension that if you don't, harm will follow. In her book, Secrets, Cicely Bach discusses why revealing the secrets of others is morally wrong. It is not just that the secret concerns matters legitimately considered private, but because the revelation will hurt the individual talked about. My argument is that the pervasive silence around abortion is a matter of secrecy in just this way. It anticipates the harm to individual women that is reasonably understood to accompany disclosure. Now, certainly there are many connections between secrecy and privacy. There's not a clear line that separates them. And both of them concern the desire to control publicity about a certain matter. This may explain why the two concepts are often blurred in ordinary conversation. There's no suggestion of anything clandestine or furtive when the answer to the question, are you having a boy or a girl, is, that's my little secret. And the practical results may be the same. If something is kept secret, it remains private. If it's kept private, it may also be kept secret, but not always so. Can you just give me an idea about the time?
Yeah, it's quite.
No, I know.
No, take it.
Okay.
Yeah.
As long as I want. Okay. In that case, I'll give you this example. A private garden may not be a secret garden, as this is one of Cicely Bach's observations. The analogy is not perfect. Information is not the same as physical space, but the image is helpful in getting at an important distinction. A truly private garden, over which one has control, doesn't need to be secret to afford the seclusion that is privacy's benefit. No one enters a private garden without the owner's consent. In the same way, with regard to control over abortion information, there's something empowering, more reputable, I think, in privacy as the preferred basis of the safeguard around the information. But the two are not the same, and I think the key distinction goes to privacy's self-evident desirability. Privacy is valued for what it provides to those who choose it. A decision is taken for privacy. This is not to say that the decision to keep something private is uncomplicated, but it simply means that it is up to the woman herself to decide under conditions which we consider fair and not coercive whether or not to disclose the matter. By contrast, the decision to keep a matter secret in the context of abortion is often a response specifically to the threat or prospect of harm. The harm may be violence or harassment or devastation to one's reputation and perhaps the reputation of a family, but there is harm there. And in such cases, the decision to keep something undisclosed, the exercise of agency connected with that decision has to work alongside the fact of fear. So secrecy introduces an element of coercion that privacy does not involve. Now, in distinguishing between privacy and secrecy, I'm not claiming that privacy is always good and secrecy is always bad. We know that in the not-so-distant past, privacy was used to shield practices of family violence from outside scrutiny. And we know as well that not all commitments to secrecy are motivated by fear. One may be obligated to keep information secret as a matter of private contract, so trade secrets, or statute, state secrets, or professional ethics, pastoral secrets. There are also voluntary secrecy pacts. Think of Romeo and Juliet and the friar. So why does it matter whether we think of the non-disclosure of information as secrecy or privacy? I think that the substantive difference between these two modes or ideal types of concealment are likely to have greater resonance in some contexts than others. And while individual cases will undoubtedly differ from one another, I contend that in the context of abortion in your country and in mine, abortion concealment aligns more with secrecy, and that in contrast to privacy, secrecy is much darker, more psychologically taxing, and more socially corrosive phenomenon. I'm skipping over thinking about what people have kept as secrets. So in the 19th century, there's a lovely book called Family Secrets, Living with Shame from the Victorians to the Present Day, just out last year, where Deborah Cohen describes the sorts of things that Victorians kept secret: illegitimate birth, a son with a propensity for unnatural crimes, suicide, insanity, adultery, bankruptcy. And I think that, she says, any of these would be catastrophic, subjecting the family to legal disability and social scorn. Now, some of these may seem quaint or unnecessary, although it hasn't been so long since homosexuality was kept under wraps, and adultery is still a crime in many American states. And while most of those sources of shame may have faded, new ones have sprung up. Smoking is an interesting example of a new kind of stigmatized behavior, at least in some places. I don't know. All right. But many long-standing sources of shame have to do with reproduction. I have in mind, so shame or failure, or I would include that. So I have in mind miscarriage, infertility, impotence, stillbirth, and abortion. And I expect that abortion still remains the greatest secret of all. And that is probably because while many of the others also involve pregnancy loss or failure, abortion alone is deliberate. So as one man stated in an interesting study comparing the disclosure of miscarriages to the disclosure of abortion, he said, it's more acceptable to talk about miscarriage. A person doesn't look like a killer. And the analogy that I make, but I'm going to go through very quickly, is with homosexuality, to use the best language of the period and not such a long ago period, where that was grounds for dismissal from work, the loss of custody of one's children, and arrests on moral charges. It isn't hard to see when being openly gay was regarded as illegal, immoral, and disgusting, and with the advent of HIV and AIDS, homicidal, that a closet, preferably locked, was a safer place. But locating locating closets within the domain of privacy doesn't quite capture the nature of closetedness, a form of concealment that is both furtive and debilitating as the fear of exposure looms over daily life. And I'm arguing that abortion is in that position now, and is because even though abortion, like homosexuality, is no longer a crime, at least in the U.S., an aura of wrongdoing still attaches to abortion. Some of it draws from the lingering language of criminality. Abortion providers are not called physicians, but abortionists. Even the word provider is used to avoid the criminal connotation of being an abortion doctor. And some of the taint also draws from the general practices that surround abortion. After all, for many women, having an abortion involves lying about where one is going and why one is going away overnight. And much of this is done sneakily. And the sneaking is quite necessary in practical terms. But as the examples I've just given you, in the U.S., there are no abortion providers in 2/3 of all our states, and we have very big states, so one often has to drive hundreds of miles. That we also have 24, 48, and 72-hour waiting periods, so even once you get there and consent, you have to go back to your motel and think about it for 72 more hours, and then you can come back and have the procedure, and various things like that. So I think there's a conceptual aspect to sneaking, too, which is for some people, women are not just sneaking to another state, but they are sneaking around the wages of sin, and there's something disquieting for others about that. So there's a characterological judgment that attaches to a woman who terminates a pregnancy. It's taken as proof of bad character with other implications for a woman's life. One example, a woman whose newborn child died in a hospital due to the negligence of the hospital was seeking damages for the baby's death. And at the trial, the hospital introduced evidence showing that she had had 3 abortions in the 10 years prior to the birth of this baby. They argued that, she argued that evidence should be excluded from the trial. And the trial court said, no, it's good evidence, we should bring it in. And the appeals court said that the hospital's claim rested on the assumption that if a woman has voluntarily consented to an abortion, she is less affected by the pain of the loss of a child than is a woman who never voluntarily terminated a pregnancy. Again, the case was reversed on appeal. The court said that introducing such evidence only serves to debase and degrade the woman and to inflame and prejudice the minds of a jury against her. But so I'm trying to provide you with legal examples of how these issues of privacy play out in sometimes in very unexpected ways, like bringing a suit for negligence. So I now want to head towards the processes by which the once undiscussable issues migrate into the public realm. And I take as my example to hold out as a template of how discussion works to open up, possibly to open up the law. The example of what in the U.S. we call birth mothers, so women who don't have an abortion, deliver a child, and then place it for adoption. Did you say birth mothers here? Yeah, okay. So for a long time, adoption was organized under a system of closed adoption. The records were sealed. Once you surrendered the baby and it was adopted by another couple, its original birth certificate was sealed, and a new birth certificate was entered with the names of the adoptive parents on as the parents. But by the early 1980s, groups of birth mothers began meeting in church basements, which is where all social movements begin, and saying that they felt a sense of loss, and they wanted to know something about where their child had gone. They were joined in this by campaigns by adult adoptees who said, we want to know who our biological parents are. And so this merger of interests, plus the fact that we now had legal abortion so that there were fewer babies being placed for adoption, and there was a very big market for babies, or certain kinds of babies, meant that legislators were interested in taking account of what birth mothers were saying, and this was a very great factor in moving toward the regime of open adoption, where birth mothers got to know some information about where their child was placed, often getting to pick the parents, often getting some forms of contact with the child even after the adoption. A huge, huge difference. And I think there was a case brought in Oregon by 7 Doe mothers, aged late 20s to early 80s, who said when the new regime was introduced retroactively, we don't want our names disclosed. We don't want any knocks on the door or telephone calls. We surrendered our babies under the promise by the state that we would have complete secrecy. And they lost because the court said you were never had complete secrecy. There were always some exceptions to when we could release those records. So they only had a very limited right of privacy. And in the longer version of this, I linger on that case a bit more because it's useful to compare their predicament with that of others with secrets to keep. And it seems to me that 3 things seem important. The Doe's initial decision to give up their babies on condition that the records were sealed was not some sort of feminine delicacy or sort of social skittishness. There were real losses to be had by keeping in what was then called a bastard. No public funding, few prospects of marriage. You're probably familiar with these. To put it bluntly, this was a time when pregnancy for women was a life-wrecking disaster. And closed adoption was preferred. And yet things change. So my first point is it wasn't unreasonable to keep that a secret. Second point is things change. Over time, single motherhood began to look less scandalous and premarital sex more ordinary. Birth mothers became satisfied with trading the protections of secrecy for greater control over the process. And legislators began to take heed of what they wanted. And so that's point 2, that things can change, including law. And the third point is to emphasize that, is to notice that law itself can be the source of both secrecy and of disclosure. So just in the Oregon case, law had kept their identities private, and then 10 years later it opened them up. Being a Doe plaintiff is a good example of the law protecting women's identities when they don't want it known. And I think these features of adoption secrecy map onto abortion in interesting ways. And where I'm heading is to the third point: how do you get things to change? My basic argument is that if there were some greater discussion at a very low level, and I don't mean reality TV. I mean confiding in your sister, telling a friend, opening up the idea that this is not something so shameful that you can never mention it, is the beginning of something, beginning of a discussion, even if it takes place only at a very private level. And I think the final goal, my final sort of strategic goal, is to have legislators think. First of all, most people think they don't know anyone who's had an abortion, and they probably do, because 1 out of 3 women in the U.S., I don't know the statistics here, will have had an abortion by the time they finish their reproductive years. When you think about it, it's not so unlikely, because the risk of pregnancy is something that can happen over and over and over again. And I think that greater respect for women who choose abortion is something else that legislators have to get embedded in their heads. That maybe women have actually thought about what they're doing, and that they don't need a 72-hour waiting period, and that waiting period is only designed to make the process worse and sort of more punitive. Actually, what I haven't got in this material, but I might as well lay it out, is I think the point of regulation in the U.S. is to come as close to punishing women as it's possible to do when you know you can't make it illegal. That would be the preferred point. But since you can't do that, let's just see how many humiliating procedures we can come up with. And if not humiliating, personally painful. So in another article I've written, we have something called mandatory ultrasound, where women must have an ultrasound and they must be offered a look, in the words of the statute, at their unborn child before they can consent to abortion. Now, many women have an ultrasound before an abortion anyway, but it's not it's for medical reasons. But this is for the state saying that doctors must do this. And indeed, in 3 states, the statutes provide that the doctor should preferably do a vaginal ultrasound rather than a tummy wand. What's that about? It's about something punitive and humiliating, I think. Okay, I'm skipping over things because I just want to tell you what the sources of the processes of disclosure, I think, are. One is something called the contact hypothesis, which is a sociological concept which says when people are put in contact with people about whom they hold certain prejudices, those prejudices, under certain circumstances, tend to fall away. Most of the early studies were done on interracial groups, and that views held by one group about the other, when they actually met people, decreased. Now, it's complicated. I'm not going to go into the critiques of social contact theory, but another Deborah Cohen, not Cowan, who did the Family Secrets book, and and I hope that nobody else with a similar name writes anything I'm interested in. It's very hard to keep them apart. Has just done a very interesting study, which you can get online. It's their unpublished dissertation, so publish your dissertations. She compared women who disclosures about miscarriages with disclosures about abortion. And what she found is that with regard to secret telling, people tend to tell secrets to people who they think will support them. So your first confiding is in someone who you think will not condemn you. That's good. We understand that psychologically. Sociologically, it has another consequence, which is people who think they don't know anyone who had an abortion, after going to church with someone who has had an abortion, still thinks they don't know anyone who's had an abortion. They still hold whatever prejudice they may hold about the kinds of women who have abortion. So that under the social contact hypothesis, this understandable reluctance to talk has the consequence of solidifying or not breaking into prejudices that other people have about bad women. And I think that's worth thinking about. How I'm not a strategist. I'm not really an activist. I mean, in my academic work, but thinking about how how women might risk some disclosure at a quiet level. Sort of, I think of this as sort of quiet activism to change the opinion of one person. My own view, if I were an activist, is that grandmothers should come forward. And I think that the reason for this is grandmothers are safe. They're nice, first of all. They're nice. Second of all, in most cultures, they're regarded as very non-sexual. So that there's a nice separation between abortion and sex, which is one of the problems. But that's another matter. Okay, the second mechanism has to do with family secrets. And I'm only going to quickly say that family secrets might be regarded as sort of group secret keeping. The whole family knows that X happened. So actually the secret isn't an entirely kept secret. And probably people in the neighborhood know. So if you bring home an adopted child and there's never been a pregnancy, but you have like a brand new child, well, we all agree that we're not going to say anything about it because it's lovely. But it's not that we don't know. And I think this is true with what were sometimes called bachelor uncles, where a family protected their bachelor uncles, and or a child sent to an insane asylum, for example. In the Victorian, this book is very interesting about secrets that people kept within the family and maybe a little broader than the family. And I think that there's room there to think about abortion. I haven't quite thought that entirely through. The third is social movement theory. And I'm just going to give you the example of breast cancer as an example of something. Here's a nice example. In a book called The Emperor of All Maladies, a biography of cancer, Siddhartha Mukherjee notes that in the early 1950s, and I'm quoting, Fanny Rossinow, a breast cancer survivor, called the New York Times to post an advertisement for a support group for women with breast cancer. She was put through, puzzlingly, to the society editor of the newspaper. When asked about placing her announcement, a long pause followed. I'm sorry, Mrs. Rossinow, but the Times cannot publish the word breast or the word cancer in its pages. Perhaps, the editor continued, you could say there will be a meeting about diseases of the chest wall. That was in the early 1950s. On May 14th, 2013, the New York Times published an op-ed piece by Angelina Jolie, which detailed in some care her high chance of developing breast cancer, her decision to have a mastectomy, and so on. Her piece was published above the line, and it used all the forbidden words. The question is, what happened in between those two dates? Well, lots of things happened, but one thing happened was Betty Ford, who was the wife of our President Gerald Ford, had breast cancer, and she publicized it. It was the first time anybody publicized it, and I remember there were posters and got little flyers that said, don't die of embarrassment. Like, say the word breast. A similar campaign, and even more, a similar and related campaign actually, was during the used by AIDS activists, what you might remember, silence, then the equal sign, death. You know. Okay. And so while there isn't quite time to develop the social movement theory as a way to understand the importance of talking about abortion, I think it is going to be quite productive in when I finish this all up. Abortion is not as easy as some other subjects, I will say. It's very hard to think of who the poster child for abortion could be. I can't get much beyond vicars, wives, and grandmothers, but we had a case, but this was a while ago. Do you know what Romper Room is? We had a program called Romper Room. It's like for little children, and has a really nice hostess who talks to them slowly in a sweet voice. It's a TV daycare program, sort of. And this woman she had 4 children. She was married, like it's respectable, and she was Miss Romper Room. That's the point. She was the hostess of the program. She got pregnant, and her husband had brought her some wonderful medicine back from Europe called thalidomide that would help with her morning sickness. Once she realized what it was, she tried to have an abortion and was not permitted to have one. This is when abortion, you had to go before a hospital committee, and she was Miss Romper Room. So I think it's very hard to think of who would be the ideal person, except that it's probably someone we all know, but it does require some self-revelation. The final thing is simply open secrets. I think it's very interesting that abortion is a big fat secret. Nobody talks about an abortion. But it's not as though the whole culture doesn't know abortion is happening. There are abortion clinics. Somebody is using them. There are statistics, 1 out of 3. There are cards in the parking lot of the abortion clinics. In the U.S., abortion is performed in separate clinics, not within hospitals, which is another sort of ostracizing mechanism. So I think the fact of open secrets is another form of moving towards some kind of acceptable disclosure. I want to say just one last thing, which is I end this chapter with a coda, because I mostly can't figure out where to put what I'm about to say, so it's just stuck at the end. But I think it's important to put abortion on a spectrum of the kinds of secrets women keep. And certainly abortion is something you don't want known, but it's not always because you're having an abortion. Sometimes you don't want anyone to know, the woman doesn't want anyone to know she had sex, or she had sex outside of marriage, or that she got pregnant. So abortion is possibly the end point, but sex and pregnancy come before, and those themselves are often sort of unspeakable things. And I made a list here of things that women keep secret, and that's what I'm heading for. So I think that reproduction is an area where women have generally, reproduction and women's bodies are something that are often kept secret. So the list begins really at menstruation and the arrival of breasts. And it moves over time to such moment as the use of contraception and sexual activity, pregnancy and miscarriage, infertility and fecundity, childbirth and stillbirth, and finally menopause. Each of these moments may be joyous or devastating, ordinary or dramatic, but whatever their reception by individual women, great care is taken as to when others can know about it. Shoulders are stooped. You often see this in teenage girls so that nobody can see breasts. Miscarriages go unspoken. Pregnant bellies are hidden under larger shirts, often so you can keep your job, or that was the case. Menopause is camouflaged. So concealment is, of course, more crucial when the activity is illegal. But I think it's worth putting abortion on a spectrum of the kinds of... It fits. It doesn't stand alone in terms of what women have been what women have reasonably kept to themselves. Well, there's more to say, but I would like to hear what you have to say. So I will stop. Thank you.